married but living together, breaking up is hard to do. People think it is easier when they are not married but living together. Unfortunately, that is not always the case. Sometimes it is harder and more expensive to break up when unmarried but living together than to get a divorce. In fact, there may be greater pitfalls to not getting married than when an unmarried couple breaks up. When unmarried couples in New York face a breakup, understanding the legal landscape regarding property rights, especially for shared real estate, is crucial. To be very clear, New York does not recognize common law marriages. You are either married by a person authorized to perform a marriage, or you are not married. When you are unmarried and living together, you are not married and do not get any of the protections afforded to a married couple. Joint ownership, both parties on the deed. In New York, if people are not married but living together, buy a house together, and both names appear on the deed, they are considered joint tenants or tenants in common. This distinction is vital in understanding each party's rights upon separation. A married couple automatically buys a house as tenants by the entirety. Unlike tenants by the entirety, whether to be joint tenants or tenants in common is not automatic. You have to tell your lawyer before the deed is drafted and signed. Joint tenancy. In this arrangement, both parties own the entire property together. If one party passes away, the other automatically inherits the entire property, a right known as the right of survivorship. Tenants in common. Here, each party owns a specific share of the property, not necessarily 50-50. 2. There is no right of survivorship, meaning if one party dies, their share passes according to their will or state law if there is no will. Resolving disputes. When unmarried but living together. When parties are not married but living together, the issue of a house is very complex. The way the law treats a house owned by parties unmarried but living together is fundamentally different from how it treats it with a married couple. When a couple is married and gets divorced, the divorce court has more flexibility. The judge can sell the property by hiring a realtor to get the best and highest price. The judge can also trade assets. For example, let's say the husband's share of the house is $150,000 and the wife's share of his pension is $150,000. The court can trade the two so that the husband walks away with his pension and the wife walks away with the house. This type of flexibility is simply not available when the parties are not married but living together. Upon breakup, the parties can agree to sell the property and divide the proceeds. If they cannot agree, one party may file a partition action in court. The court can order the sale of the property and divide the proceeds according to each party's contribution or agreement. The partition action is not pretty. The partition action, the cons, not really any pros. Lawyers hate partition action on residential homes because there are no winners. The idea of a partition action arose from farmland. Unfortunately, the law has not kept pace with the reality of unmarried people buying houses together and then splitting up. Clearly, this doesn't work for a residential home bought by a couple who is not married but living together, or as I said above, any group of people owning property. The house has to be sold. Once the complaint is served, the court will appoint a neutral third party, known as a referee, to evaluate the property and make recommendations on the most appropriate partition method. The referee will typically visit the property and inspect it. The referee is paid for by the parties. The referee will submit a report to the court detailing their findings and recommendations. If the property cannot be divided, whether the property should be sold and the proceeds divided among the co-owners, based on the referee's report, the court will issue a judgment determining the appropriate method of partition and outlining any necessary steps to complete the process. If the court determines that the property cannot be physically divided, or if the parties cannot agree on a physical division, the court will order a partition by sale. In a partition by sale, the property is sold and the proceeds are divided among the co-owners in proportion to their ownership interests. The sale is an auction on the courthouse steps. When a realtor sells the property, he is seeking the best and highest price. That doesn't always happen at an auction. The house may be sold for under value and may in fact be sold for under the outstanding balance of the mortgage. That means the parties no longer own the house, but are still liable for the mortgage. Single ownership, one party on the deed. Situations where only one party is on the deed are more complex. The non-titled partner may still have rights based on contributions to the property's purchase or maintenance. When parties are married, all property acquired during marriage is marital property, regardless whose name is on the deed. But when the parties are not married but living together, The person whose name is on the deed is the owner. The non-titled partner must prove their contributions to have a claim. This can include financial contributions towards the mortgage or significant contributions to the property's upkeep and improvement. Legal remedies. 1. Constructive trust. A court may impose a constructive trust if it finds that the non-titled partner made contributions with the expectation of a shared interest in the property. 2. Partition action. While typically used for joint owners, a non-titled partner who establishes a claim may seek a partition action to receive a portion of the property's value. Legal agreements. The role of cohabitation agreements. Unmarried couples are encouraged to have a cohabitation agreement. This contract outlines each party's rights and responsibilities regarding property and can be crucial in resolving disputes efficiently. If you really don't want to get married and really want to buy a house together, go to a lawyer and get a cohabitation agreement. Yes, you can save money and pull a blank from the interest. But do you really want to take a chance when hundreds of thousands of dollars are on the line? Enforceability and requirements. A cohabitation agreement must be in writing, signed by both parties, and executed voluntarily. It should be clear, specific, and fair to be enforceable. Courts are very strict when examining and applying contracts to real property. Again, you are strongly advised to get an attorney to draft the agreement, protecting your rights. Legal representation. Considering the complexities of New York property law, seeking legal counsel is advisable. An attorney can provide tailored advice and represent your interests, whether in negotiating an agreement or litigating a dispute. Documentation. Maintain thorough records of all contributions towards the property, including mortgage payments, renovations, and major repairs. Conclusion. Navigating property rights in the context of a breakup for unmarried couples in New York requires an understanding of the legal framework and the different scenarios that can arise. Having a cohabitation agreement and seeking legal advice are key steps in ensuring a fair resolution. Not married and living together may seem like an easier option, but as seen above, it can lead to greater complications. My advice: don't buy a house together, and if you're going to do that, then get a cohabitation agreement. If you have questions, call us at Port and Sava at 516-352-2999 for a free 15-minute telephone consultation.